Hello, I'm Bill Tingley. Every day, in courtrooms just like this, families seek help to solve their personal crises. Whether it's divorce, child abuse, or other family problems, the judges of family court try to decide the best course of action to help families work out their problems. We're going to take you inside family court to hear from the judges who make the decisions which change the lives of thousands of people in Jefferson County each year. Today's guests are Steve Veno, Director of Kentucky Child Support Program, and Judge Mason Trenaman, Family Court Judge for Division 4. Our topic is child support. Judge, child support is one of those terms that we all use, but I'm not necessarily sure that we all know what it means. When a person is paying child support, generally, what are they paying for?
Generally speaking, child support is just what it says, funds to support the child, whether it's for the mortgage payment that the mother has to make, the rent payment that the father's making, all of the food that's provided for the child, clothing, shelter, all of the day-to-day necessities for that child should be provided out of the child support award.
All right, this is not standard of living money. This is not go out and buy necessarily the expensive toy or something like that. We're talking about the basic needs of the child.
We're talking about the basic needs of the child, but remember, in the Commonwealth of Kentucky, we now have child support worksheets and guidelines in place. The amount of child support itself is now set based on that worksheet. That worksheet is based on the gross income of the two parents, with each parent having a certain percentage of responsibility based on the amount of gross income that they bring into the family.
So there is kind of a standard of living factor to it. The more money the parents live, obviously, perhaps the more that can be provided for the support of the child.
When the legislature enacted the child support guidelines, they essentially told the courts, here are the needs of the child. Here is what it costs to raise this child, and they base those needs upon what the parents make. Obviously, if you have a doctor who is making $100,000 a year, he's probably going to support his child at a higher level because he has more income available than is somebody who is making $20,000 a year. But all of that is covered by the guidelines.
Now, the guidelines came into effect when? We haven't always had these, have we?
I believe the guidelines have been in effect for 8 or 9 years now. No, we haven't always had them.
What did they do before the guidelines?
Before the guidelines, the decision on child support was much more up to the discretion of the trial judge. Today, once we do the basic calculations, we set out that here is the gross income of mom, here's the gross income of dad. We work through the calculations, giving credit for health insurance cost, giving credit for older children who are supported by either of the parents, and adding in a contribution towards daycare. We come to a bottom line amount of child support that is going to be entered in most all cases. In fact, in order to deviate, before I as a judge can do anything else with that child support award, I have to make very specific findings that there is good cause to deviate from the guidelines. Child support is all but automatic now unless I make that finding. One reason to deviate could be special medical needs of the child.
Certainly.
Other than that, the orders are by and large going to be entered at the guideline amount.
Certainly. And is, with this guideline chart, do you find occasions when, let's say both parents are doctors and have very high-paying jobs? Or what's the guidelines do with folks who make more money than the chart even sets out a level for?
There is no good answer to that question right now. There is a split of authority in the Commonwealth of Kentucky as to whether child support continues to increase as parents get more and more wealthy, or whether the basic level of child support tops out at some amount. So there is no good answer to that question, and either fortunately or unfortunately, it's not a situation we have very often. Unfortunately, the situation that we usually have is that neither mother or father are going to have enough money to continue to live at the same standards that they lived in while they were married.
Certainly. Who is child support paid to?
Child support is payable to anyone who is the caretaker of the child. If the mother has custody of the children, dad will be ordered to pay child support. If dad has custody, mom will typically be ordered to pay child support. Remember, however, that when we're talking about paying child support, we're not saying that only one parent is responsible for that child. Mom or dad will physically write a check to the other parent that covers their portion of the expenses. That custodial parent isn't going to then sit down and write a check to himself or herself for his or her share of the expenses. They simply take their money and pay for rent, pay for food, pay for clothing. In addition to mother and father, if grandmother, if the aunt, If any caretaker has custody of the child, they can get a child support award against the parents.
What about if the child is in state care?
If the child is in state care, either through the foster care system or some placement, or even if aid is being paid, some sort of aid to families, AFDC is being paid to the parents, then child support can go to the state, and in fact will go to the state in those circumstances.
I want to get to Mr. Veno here in a moment, but I want to set up one more piece. When the child support is established, how does someone go about getting that done?
Establishment can be done typically in one of two different court hearings. The first is through your typical circuit divorce case. Mama and daddy are getting a divorce and child support has to be established. It will go through that circuit court action. Secondly, and increasingly in the 1990s, we have cases where mother and father were not married and the child is born out of wedlock. In those cases, the paternity court will establish and enforce the child support order. So whether married or not, either the circuit court or the district court will have jurisdiction to set a child support award, and it's up to the custodial parent to go to that court with a motion, either with an attorney, through the county attorney's office, or pro se, that is representing themselves, to get that obligation set. If I were saying one most important thing for people who are beginning this process to remember, it would be that child support cannot be ordered retroactively. If mom or dad has the child in their custody and need a support award, they need to apply for that award today. If they wait 5 or 6 months or a year and then come to the court and say, Judge, I've had these children in my care for the last year, I need back support, the judge has absolutely no authority to enter such an order. It can be effective only as of the date that a motion for child support or a petition for child support was filed.
Now, we go in and we ask for child support. Are you going to be the one who does the math, or do you have some help in terms of the literal calculation of it?
Once the petition or motion for child support is filed, there are a couple ways for it to get in front of the court. One, it comes to the court directly, and we will have an actual hearing where the two parties tell us about their gross income, health insurance cost, daycare cost, etc., and the court calculates. Many counties, and Jefferson County as well, also utilizes the services of a Jefferson Domestic Relations Commissioner. Well, us, it's the Jefferson Domestic Relations Commissioner. Other counties, it's simply Domestic Relations Commissioner for their county. We will refer the case. Sometimes it would take you a little bit of a length of time in order to get in front of the court. Rather than making you wait 45 days to come before the court to tell us these things, we'll give you a referral to the Domestic Relations Commissioner. They can hear your case rather quickly, get recommendations to us, and then we'll sign the child support order.
Okay, we've got a child support order now from Judge Trenaman. Mr. Veno, let's say it's 2 years ago, and that child support order came in a paternity case. Who would the check have been made to?
In a public assistance situation, the check should have been made payable to the Cabinet for Families and Children.
Okay.
Those funds are received by our agency and applied toward the public assistance grant that is paid out on behalf of that child.
Would I have mailed the check locally, or how was that collected 2 years ago?
2 years ago, it was paid through the county attorney's office.
Okay.
And other areas of the state, they were paid to various area offices, domestic relations offices, and circuit clerk's offices.
We're getting ready to have a change, though, aren't we?
Yes, sir.
Okay, tell us about that.
In the Welfare Reform Act of 1996, the Congress enacted some changes that is going to dramatically impact all states in the way wage assignments are paid. Wage assignments currently in Kentucky are paid to a variety of local entities, as I described, domestic relations offices, circuit clerks, friends of the courts. We even have a couple of county attorneys that are collecting support in western Kentucky. However, that all is going to change in the next several months. We're required to have all wage assignment payments payable directly to a state centralized collection unit.
Now, let me stop you. When you say required, who's requiring it to happen?
Congress.
All right. So this isn't Judge Trenaman waking up one morning and having a brainstorm and going to change all these child support orders.
No.
Okay, this is our legislators who've had that brainstorm.
This was Congress,
Right.
and of course we did enact statutes in this last General Assembly to correspond with the federal mandates.
Okay, have we begun this process yet anywhere in the state?
Yes, in fact, last year we looked at how would we do the process, and you had either two approaches. One, you can hire state staff to do it, or you could look to the private sector to do it. We chose to go to the private sector, number one, because they could do it much cheaper than the state could, plus they had resources, technology available to them where they could do it much quicker than we could.
When you say do it, you're talking about receiving all these funds from across the state and
Yes.
then turn around and dispersing it.
Exactly. And beginning last year, we moved all cabinet for families and children payments to our centralized collection unit. And they have been posting payments the day of receipt, and most often payments are mailed within 24 hours. Depending on weekends and holidays, it may be 48 hours, but they're doing an excellent job. And those payments across the state were being paid to 20 different locations across the state in our local area child support offices.
Okay. Gentlemen, we're going to take a break right now and then we'll come back. Thank you. Steve, what is your understanding of why this change is taking place?
The state registry?
Right, the change from payment to the county attorneys and to the local funds to the state fund.
Basically is to get a better handle on the collection system. The main problem was that in Congress they were tightening down the time frame that employers were required to comply with wage assignment distributions. And the problem for many employers was that from state to state you could have a multitude of places to pay support. So to make it easier to do wage assignments, for employers to know where to send a wage assignment within a limited time frame, Congress asked that states have one point in their state to pay child support. And particularly this is beneficial to multi-state employers who not only could have more than one state involved, but numerous jurisdictions within those states they would have to figure out where to send the money to.
Understand. What about the state registry? I understand that along with the passage of this bill was a requirement that the states create a registry. Explain that for us.
In the act, Congress also required that states set up a state case registry of all child support orders. And that includes, again, the cases the Cabinet for Families and Children are responsible for, but also private cases. And this registry will be uploaded to a federal case registry. And the reasoning behind that was, number one, for the child support system to really get a handle on the how many child support orders out there we were dealing with, but also too, it could be a resource for people to go to find out how far behind their payments are in those situations where we didn't have a local collection entity receiving those payments or someone keeping track of it.
Is there any plan that interface with the tax intercept laws that allow for tax refunds to be garnished when there is default?
No, not in private cases. In the private cases, we're just going to act as a pass-through for the money. Comes in the door and out the door. If, however, they do want to seek our service, if the person becomes delinquent, they can apply for 4D child support services for free.
Okay. I want to get back to Judge Trenaman here, but I wanted, you mentioned private versus non-private, and I think it's important that we make clear to our audience that payments that are made via a paternity action where the Commonwealth has been involved, the state or the county, These are the non-private. Privates are just the divorce, where the state was never involved. But those are going to be paid eventually through your system as well.
The private wage assignments
Yes.
will be, and the registration of court orders will be required.
Okay, but not yet.
Not yet.
So don't send your money to the just keep sending it where it's been
Exactly.
going.
Wait
All right.
till you hear from us, and we're hopeful to have all this completed statewide by the end of this year.
Great, great. Judge Trenaman, I wanted to come back to you, talk a little bit more about establishment, and then talk about enforcement.
Sure. On establishment, we briefly mentioned it a few minutes ago. There are essentially 3 ways for a parent who is looking for support to approach the court. They're going to approach the court, as we've said, either in the paternity court if the parties were not married, or in the circuit divorce court if the parties were married. They can approach the attorney through the court through the traditional method of hiring an attorney. An attorney comes before the court, that person pays his or her attorney, and they file a motion on behalf of the client. That's the way that most people have historically approached child support. The second major avenue that has evolved a great deal over the last 10, 12 years particularly is to utilize the services of the county attorney. Here, the Jefferson County Attorney's Office will prosecute, and I don't use that term in a criminal sense, but will go forward with a case to establish child support, either in the paternity case or in the divorce case in certain circumstances. The county attorney's office does a wonderful job. The only caveat that I would issue would state that the Jefferson County Attorney's Office has a caseload of active cases, someplace between 40 and 50,000 cases.
Wow.
Because of that, even though the workers are working really hard, the attorneys are working really hard, sometimes there is downtime before they can offer you those services. So the good part is they will do the work for free, as Steve has said. The bad part is sometimes it will take a little bit longer.
When someone comes in pro se, I think it's important too that we talk. Pro se, of course, means on their own without a lawyer. What standard of behavior, if you will, are they held to?
Pro se is the third way to get an enforcement or to get an order entered. That means that you represent yourself. You are, generally speaking, going to be held to the same standards as an attorney. The rules are relaxed just a little bit to make sure that people understand what's going on. But certainly notice requirements where you have to notify the other parties, right, and you have to file your motions in a proper form are going to be followed. Here in Jefferson County, the Family Court Clerk's Office has some forms that are helpful for pro se litigants. So it can be done. It simply takes a little bit of homework for the pro se litigant to represent himself or herself either in an establishment action or in a civil enforcement action.
You've established the order. Steve's received a little bit of money, but hadn't received everything that should have been paid. It's supposed to be being paid to me. What do I do?
We've gone through the process now that mother or father have determined here's how much child support I get under the guidelines. I've gone to court and had the court set an order either in paternity court or in the circuit divorce court, and now I need to enforce that order because I'm not receiving my funds. There are essentially 3 major enforcement mechanisms and then a 4th one I'll hit basically. The first enforcement mechanism is purely a civil action. You or your attorney would go to the court and say, Judge, I am due money. Here is the child support order that I have in effect. Here is how much I've been paid. This person owes me X amount of dollars. I want a common law judgment for that amount. Assuming that the proof is good, the judge will grant a common law judgment. That will let you act the same as any other creditor, the same as anyone who sold you an automobile, sold you a house, has a judgment because of a lawsuit. You have a valid judgment that you can execute upon. Purely civil, no sanctions, nothing other than a judgment with interest from that date forward. Secondly, you can come before the court and ask that the court find that person guilty of contempt. Contempt means that a person knew of a court order, in this instance in order to pay child support, that he or she disobeyed that court's order, meaning they did not pay child support, and that he or she does not have a valid excuse or a defense for not making that child support payment.
Can I do both?
You can do both the common law judgment and the contempt sanctions.
Because the contempt, as I understand it, it's a the punishment in contempt, you're violating just the act of not following a court's direction.
Contempt means simply that you're violating a court's order. Okay. Assuming that I have made a contempt finding, the most that I can do for any particular contempt finding is to fine the person, which would do no good because my goal is to have child support paid.
Right.
The last thing I want to do is issue a fine that causes less dollars to be available for the child support. So what we traditionally do will be impose a sentence of incarceration. 30 days for each count is the maximum, a total of up to 6 counts for a total of 180 days. That is the most you can do under contempt sanctions. Typically, you would start off with a period of probation, 180 days probated. So long as that person paid child support, we have done what we were supposed to do. That's all we're interested in. In addition to the common law judgment and contempt sanctions, there is also criminal non-support. Criminal non-support is different than contempt because it is actually a criminal action. There are 2 kinds, either misdemeanor non-support, where the person could go to jail for up to 12 months, or felony or flagrant non-support, where the person could actually go to the penitentiary for 1 to 5 years on a Class D felony. The elements of those are that the person had an obligation to pay child support, the person didn't pay child support, and he or she does not have a defense. The advantages to the criminal non-support versus the contempt are that the sanctions are much, much higher. You've heard the term speak softly and carry a big stick. Truly, the flagrant non-support warrant is the biggest stick you can carry, and it very rapidly gets the attention of parents who don't pay child support.
And I think under federal law, there's national enforcement of those, is there not?
There is national enforcement actually under both paternity and the criminal non-support. The 2 advantages to criminal non-support are 1, the sanctions are much tougher, and 2, you don't have to get service of process. The contempt sanction I talked about a few minutes ago is a civil lawsuit. The mother is suing the father, or vice versa, for not paying child support. Before I can take any enforcement actions, before I can give that 30 days in jail we talked about, I have to have proof that the sheriff served him with the paperwork, because this is a lawsuit, and have to have proof of that. Sometimes, believe it or not, the mother or father who isn't paying child support is not going to want to be found by that law enforcement person. They're going to hide. That's the other great advantage to the criminal case. A warrant can be taken out. It is a criminal case, not a civil case, and you don't have to have that service of process. So those are the 2 primary differences between criminal and civil.
I've had a criminal warrant served upon me, and it alleges that I have not paid my child support. What do you want to see for me to be able to get out from underneath of this and show you that, in fact, I have paid my support?
I want to see the pay records. Sometimes people will come in and say, Judge, I have paid my child support. They've taken it out of my check each and every week.
If I bring in printouts from the cabinet's child support payment system and it shows that I've got a 0 balance owed, is that the kind of proof that you're looking for?
Showing that you have a 0 balance owed is not necessarily going to be what I need to see, because we're dealing with certification of past arrearages, we're dealing with different time frames, we're dealing with lots of different records. When Steve talked a few minutes ago about 20 different enforcement agencies, one enforcement agency may only have had an order for a period of 6 months, and that piece of paper may say $0 are owed, but it's for a limited time period. I want to go back to the original date of the order, and I want some form of proof that a payment has been made each and every week or each and every month, depending upon the order, when it was due. Copies of checks from the bank, copies of pay records from the county attorney's office, copies of pay records from Frankfurt Division of Child Support. All of those things in conjunction with the other will work. A simple letter from any agency that says this man or this woman owes nothing is probably not going to be sufficient, because it won't have enough details to let me know, are we truly talking about 0, or are we talking about 0 only for a very limited period of time?
How about, Judge, I didn't pay that amount, but I did go out and buy the child some clothes. Here's my receipt. Is that going to get me off the hook?
That's not going to get you off the hook, and lots of times in cases we will have one parent who wants to be the good guy or the good woman, and mama or daddy has to go out and pay the rent, has to buy food, has to buy clothes, and the other parent wants to step in and buy the bicycle. That's not going to work. A support order is a support order, and you have to be in compliance with that order. It's not enough to say, Judge, I also bought some t-shirts. You have to prove that you complied with that court order.
Very good. Gentlemen, I very much appreciate you being here. Mr. Veno, we don't want checks yet. Is that correct?
That is correct. Do not send us any checks until we contact you.
All right.
Do not send any checks to Frankfurt until they contact you. Keep sending your checks to the place you're sending them now.
Very good. Gentlemen, thank you very much. We're going to take a short break, and we'll be right back. Mr. Veno, Judge has talked about some of the enforcement mechanisms. Are there any other ways that we have, laws that we've designed to enforce child support obligations?
Yes, we've had a fairly effective enforcement remedy we've had in place since '96, and that's driver's license revocation.
How does that work?
Basically, you go down to the county attorney's office or our local child support office. If the person has an arrearage equal to 1 year, we'll take action to suspend their license, and it's purely an administrative process. It goes through the cabinet, and we send it to the Division of Driver's License and the Cabinet for Transportation, and they take the license. However, we do have a due process procedure where they can appeal, they can ask for hearings prior to that taking place. Also, we don't expect someone to pay their arrearage all in one lump sum. For example, if they owe $10,000, we don't expect them to pay $10,000 to avoid losing their license. If they can enter into a reasonable payment schedule with us, we won't proceed as long as they comply with that.
Are other occupational licenses also part of that process?
Yes, part of the Welfare Reform Act, we take that a step further, and we also now have the authority to revoke professional, occupational, recreational, and sporting license.
Judge, I've got a child support order against me. I don't like it. I don't like it so much I'm going to move to Montana. Is that going to save me?
It's not going to save you. It's going to make the process a little bit more complicated from the enforcing parent's perspective. We now have interstate acts. The acts have been around for a number of years in one form or another. We're now in what's called UIFSA. It's not important to remember the name. It's important to remember that mother or father with children in Kentucky can enforce a child support order against a father or mother in any other state by going to their county attorney's office or even a private attorney's office, beginning the paperwork in this state as the initiating jurisdiction. Kentucky will forward the paperwork to the appropriate court in the state of Montana or any place else. That jurisdiction will then prosecute the order under their laws against the mother or father in that jurisdiction, get the money flowing back to Kentucky. A little more time consuming, a little more technical, but if you jump through the hoops, you can certainly have good enforcement through the Interstate Act.
It would be an understatement to say that how we handle child support has changed dramatically in the last 5 or 6 years. Judge Trenaman, thank you for your time. Mr. Veno, thank you very much for your time.
Thank
Thank
you.
you.